I'll need to see everyone that's on the platform, please. This is Judge Leanderson. All right. Hello, Ms. Benedict. All right. And who else do we have here today? Mr. Luce? Okay, and I can't hear you, sir. Mr. Luce, you're on mute.
How about now?
Yeah, I can now.
Okay. Mr. Constantine is here as well.
Good afternoon to the court.
Okay, hello, Mr. Constantine. Okay. I'll need to see you, Mr. Luce. So Mr. Constantine is and his role is you're the attorney, is that correct, Mr. Luce?
That's correct.
Okay. And you're representing Mr. Mickelson. So, and then Gail. Who do we have, Gail? And who do we have on the phone? Who do we have? Does anybody know? Okay.
I was on the phone, Your Honor, but I hung up. I wasn't sure I was connected correctly.
Okay, well, I'll tell you, first of all, well, let's see, who is 253-922-8724?
That is my office.
Okay, then we don't need that anymore, right?
That is correct.
Okay, one down. Now I have Gail, and who is Gail? Is it Ms. Gail? It says Gail, she, her. Who is that? Can you unmute, ma'am, or please?
Your Honor, if I may, it might be Gail Mickelson, now Gail MacArthur.
Okay, well, Gail, I think, has left. All right. So it looks as though we have, and I'll just let you know, we had 3 different dockets, or we had other dockets this morning. I'm a family recovery court, and that's a drug court docket for dependency cases. That is my first docket on Friday mornings. Then my regular civil motion, and I do my Zoom matters. If there's a Zoom request, I do that at the after I've completed all of my others. So we just finished up with our morning in person. So I know we're into the noon hour, but unfortunately that's where we are. So this is cause number, make sure I've got, hang on just a minute. 16-400-8618. I believe that's correct. And this is a motion. Got a motion by Mr. Mickelson. So if I could have the parties introduce themselves for the record, and we'll start with Mr. Mickelson.
Well, good morning, Your Honor. My name is James Mickelson.
Okay, I appreciate that your attorney will be speaking for you, but thank you for letting me know that you are there. Thank you.
Okay.
Okay, go ahead, Mr. Luce.
Your Honor, I'd like to take my time and a few minutes and then give the remainder to Mr. Constantine.
Wait. Hold it just a minute. Who is Mr. Constantine of record on this case? Is he the attorney of record?
No,
Your Honor, I have filed a notice of association. It's in the file. I've worked with Mr. Luce on this matter and other matters since 1992.
Okay, I was not aware of this. Let me take a look at the file, sir. Hang on.
And Your Honor, Heather Benedict, if I could just make an objection on record of Mr. Constantine, The notice of association is not, my understanding is not the same as an appearance. It's unclear if he's limited, full, special. So I just want to make that record. It's just a notice of association and not appearance.
Okay, I appreciate that. I'll take a look. Thank you, ma'am. Okay, so got a notice of association. Let me see, what do we have? All right, when was it filed? Did you see it, Gia? When was it? Okay, so May 7, 2024. Notice of Association of Council. Okay, so I just had not seen your name, Mr. Constantine, on the pleadings that were filed, and I may have missed that. So are you going to be providing argument today? You're going to be speaking, or is it Mr. Luce that's going to be speaking?
We're going to split it, Your Honor, just briefly the history, and then Mr. Constantine will take it over.
All right. Well, I do see that he did file an association. Okay. All right, so go ahead. So the motion before me is, why don't you explain what, and thank you for introducing yourself. And Ms. Benedict, you introduced yourself. Thank you. So go ahead, Mr. Luce, and the motion before me is, why don't you, let's place that on the record, sir.
Motion before you, Your Honor, is to open a probate. Now, do you have any specific questions or areas that you would like me to cover?
Well, who's going, so you wanted to give me the background. I'll tell you, I reviewed the record and I went back as well to the infancy of this case, which was back in 2016, when the, did you print that off for me? Thanks. When the petition for adjudication of intestacy and heirship was filed by Ms. Was filed, and let's see, I think that the petition was filed on May 16 of 2016. And then a month later, within a month, it was dismissed with prejudice following Mr. Mickelson's motion to dismiss. So I do have that. I've got that. And it was dismissed because of the existence of a community property agreement. Is that correct?
That is correct, Your Honor.
All right. So what you're trying to do now, what you want to do now is you want to open a probate.
That is correct. By way of background, Mrs. Mickelson died about 12 years ago.
Ms. Benedict, I will allow you to speak. I'll allow you to speak. Okay. You'll get your opportunity. Go ahead.
By way of background, Mrs. Mickelson passed away. And as the court knows, probate was filed by Ms. Benedict, and it was dismissed with prejudice. Since that time, actions have been filed in Pierce County, King County. A probate was dismissed in King County within hours. A second probate was filed. There have been, I think, numerous cases that are on courts of appeal, and I think there's one up there now on appeal. But basically what happened is that Mr. Mickelson, being unaware that the recorded property agreement gave him all the interest in the real properties, unbeknownst to him, Ms. Benedict had herself appointed as the personal representative of her mother's estate in King County without notice to anyone. And then she got herself appointed as personal representative without notice to anyone. And she executed a deed conveying real property to herself and her brothers and sisters and to Mr. Mickelson of community property that passed to Mr. Mickelson when his wife passed. So what we faced with is a deed that she made, and 5 years later, she recorded it. And that's when we became aware of it, when actions were being taken regarding the property. It has placed a cloud on the title. The purpose of this motion is to open the probate to void that deed, and so we can convey it to the next owner. The estimated value of the property is $1.8 million. Now, at this time, I'd like Mr. Constantine to address the legal issues of the matter.
All right. Okay. All right, Mr. Constantine.
I will respond to the response that was filed by Ms. Benedict on June 4th. She takes the position that on May 7th, there was a hearing in front of Commissioner Farmer, and it was decided that if the probate was reopened, a professional administrator would be required to be appointed at the expense of Mr. Mickelson. I have in hand the May 13th order that Commissioner Farmer signed following that hearing. And the word administrator does not appear in that order. So Ms. Benedict's argument that it was decided that a professional administrator would be appointed nowhere appears in Commissioner Farmer's order. Okay. Then Ms. Benedict argues on May 31, 2017, and on December 16th, 2020, the King County Superior Court entered an order that it retains jurisdiction of all matters related to the estate of Ruth Mickelson. That's in King County case number 17-4-02196-0. And permission to file a pleading must be sought by Commissioner Henry Judson. I have in hand the an order from the King County Superior Court in that cause number dated December 16th, 2020, signed by Commissioner Velategui. And in paragraph 4 of that order, he states, all future pleadings in King County Superior Court related to the estate of Leanna Ruth Mickelson will not be accepted by the clerk of the court absent an order from Commissioner Henry Judson that the matter may be filed. That order nowhere mentions any proceeding outside of King County. So this petition that Mr. Mickelson filed last month is not affected by that order, because by its terms, the order prohibited filings in the King County Superior Court. So
Okay.
she next argues that Mr. Mickelson had been appointed personal representative in the King County Superior Court from May 31, 2017 to December 16, 2020, and that he had 3 years to review the accounting from the prior personal representative and make objections to any property transfer, and he did not. That overlooks the issue that in the May 2016 deed that was issued by Ms. Benedict, no one was notified. Mr. Mickelson didn't find out about the existence of that deed until I believe it was 2022 or 23. So he can't be faulted for something when there was no notice given to him. And also there's reference made by Ms. Benedict to the court's May 2016 order of adjudication and intestacy and heirship. In this case, in the 861 cause number, I challenged the court to review the record to find that May 16th, 2016 order. I've reviewed the order in the Pierce County file. I can find no such order, nor can I find any notice to any of the heirs that such an order was being proposed. And also, we have the June 17th order from Commissioner Johnson, which denied, it was entered on June 7th, 2016, and Commissioner Johnson denied the petition for adjudication of intestacy and heirship. So something is quite at odds here. She's alleging that there's a May 16th order of adjudication that doesn't appear in the file, and yet Commissioner Johnson dismisses her petition in June of 2016. Something isn't right here.
Okay. All right, hang on just a minute. Well, I have a June 17, 2016 order. Signed by Commissioner Dickey. So you've got one for Commissioner Johnson?
Yes. It's filed in open court, ex parte department, Pierce County Superior Court, cause number 16-4000861-8.
Okay, I'll pull it up. Hang on.
It's interlineated on lines 24, on lines 21 and 18 to 22, where it's stamped denied and handwritten. All parties have been put on notice there is a contested issue regarding intestacy. Signed, Commissioner Johnson.
Okay, just a moment. Okay, I'm sorry, Mr. Constantine, what was the date of that?
June 7th, 2016.
June 7, 2016. Okay,
That's what the date it was filed.
all right. Oh, okay, okay. Okay. All right. So, okay. Yeah, I'm just, I've got to look back into, there's a fair amount that's been filed in this case, sir. So, okay. So now, just because I was looking back through trying to find, and I had printed off a certain number of the earlier orders, but I didn't print off everything so that I had it right at my fingertips here. Okay. So the purpose of, so what is your argument concerning that order, sir?
Well, it's an order that denies Ms. Benedict's petition for adjudication of an order of intestacy and heirship.
Okay, right. Yes.
But she's maintaining that an order was signed. I believe it. I've seen that order. It was signed by then Commissioner Kuykendall. But it does not appear in the docket. It's the May 16th, 2016 order of adjudication and intestacy. and it's nowhere to be found on links.
Okay, so May 16, I don't,
It's not there.
May 16 that I see, and I'm looking at dates that things are filed. So you're saying that there is an order that was not filed? An order entered that was not filed?
An order entered that was not filed, nor do I find any notice to any of the heirs prior to the execution of that order that would notify the heirs that such an order was, that very important order was being entered.
Okay.
And if the heirs were not notified under Hestaken versus Harvey, 78 Washington 2nd, that order would be void. So we maintain, absent any proof that the heirs got served, whether it was filed or not filed, that's a void order.
Okay, so here's the question that I have for you, okay? Because why, and I'd like an explanation in terms of okay, this of why you believe you need the probate to be opened. Why, as opposed to just filing a civil lawsuit against Ms. Benedict for the allegations that have been made, sir. Because, and the reason I say that is that the petition, her petition had been filed May 16th. June 17th, the case was dismissed. And the reason the case was dismissed was because there was a community property agreement.
Yes.
So in the event that some malfeasance occurred during that time, and you're making many different arguments concerning various notice requirements that were not complied with, but there was no basis to begin with for the matter to go through probate, because there was a community property agreement that covered the distribution of all of the deceased's property.
Well,
Am I missing something?
yeah. In May of 2016, Ms. Benedict, acting upon the May 16th order, executed a personal representative's deed.
Okay. So which order was she acting upon? What's it called?
It's the May 16th order of adjudication and intestacy.
Okay, I
3
see.
days later.
I don't have it. Do I have that? What date was it filed?
Well, it was recorded on March 24th of 2022.
Okay, I'm looking.
The document is dated as May 19th of 2017.
Okay, May 19th. So it was filed with the court on May 9th. I don't have a.
No, it was not filed in the court. It was recorded with the Pierce County Auditor on March 24th of 2022. And it was done in her capacity as a personal representative. It was recorded 5 years after it was executed.
Okay, so was that a document that was required to be filed with the court? Because I don't have that document here, sir. So if somebody was doing something, I mean, what I'm looking at is whether or not there is a basis. And right now, I'm not seeing that there is a basis to reopen the probate. I'm not saying that there might not be some remedy against Ms. Benedict for some alleged malfeasance, but I am not seeing because there was no basis to open up a probate to begin with. And the court, from my review, dismissed the petition that was filed by Mr. Mickelson, or on Mr. Mickelson's behalf by Mr. Luce, shortly after the petition was filed. So isn't there another, I believe that there's another remedy, and I don't believe opening up a probate when a probate was not required to be, when there wasn't a basis to open the probate initially because of the community property agreement, the existence of. Okay?
But this asset was an estate asset. It was land. It was an asset of the estate of Heather Leanna Ruth Mickelson.
Well, I thought that what you were telling me, or Mr. Luce was telling me, that the community property agreement governed all of the property and everything went to Mr. Mickelson upon his wife's death. Correct?
Yes.
Okay. So
Property still would be an asset of the estate for purposes of administration.
okay, but you, Mr. Luce, on Mr. Mickelson's behalf, argued, brought a motion after the filing of the petition to dismiss. And so there was, it was immediately dismissed. So if something happened, and I believe that there is another remedy rather than opening up a probate that didn't have any basis to be opened up to begin with.
Your Honor, if I may, Ken Luce, what we have here is a situation that places a cloud on a piece of property worth $1.8 million. The title company has told us that we have to void that deed. And since it was executed in the capacity of the personal representative of the estate of Leanna Mickelson, that it was the state's property, and on paper at least, when it got transferred, that we're trying to clear it. And the easiest way for them to get it clean and get it cleared is to put it.
Hang on just a moment, just a sec. Sir,
Oh, I'm sorry.
okay, are you recording?
No, absolutely not. I have some people at home that I told them I'm still in the hearing. I can give you a couple more minutes.
All right, if you need to use your phone, please go outside of the courtroom. It's distracting to the court. All right, thank you, sir. All right, so that interrupted things. I'm sorry, Mr. Luce, go ahead.
Well, the situation we have is that basically what we have is a fraudulent conveyance of a piece of real property that's also a crime. And the owner of the property, according to the record, is the estate who was the grantor in the deed. However, we know that not to be true because of the community property agreement placed title to it in Mr. Mickelson. To void the deed, we should encounter the act of the personal representative by voiding what they did, canceling the deed, making it matter of record to clean the title so that we can transfer the property.
Well, and that may very well be what you need to do, but I don't believe that opening up a probate is the way to do it. So I think that you may need to file an independent lawsuit against Ms. Benedict if she did not have the legal authority to do what she did, because the case was dismissed. Everything was to be transferred pursuant to the community property agreement. So unless you can provide me some legal authority to say otherwise, I think that you may, I'm not saying, but you may have a lawsuit against her. And but for me to open up a probate when the probate was not, when there was no basis to open a probate to begin with, I don't see the authority for me to do that. Okay. So what I'm doing now is I'm denying the motion. And I would suggest that you seek redress by perhaps an independent civil claim against Ms. Benedict. But in any event, I'll leave that, of course, to you. I'm not going to be providing any legal advice on that. But if she did something that she did not have authority to do, then you may have redress against her, but it would be through an independent lawsuit. All right. So I'm going to file an order today that denies Mr. Mickelson's motion, and we will go from there. All right. Thank you all very much.
Thank you, Your Honor.